We are just about to begin our working session 2. Mr. Raj Panchpatia, please. I'm giving my reins to him.
May I now request all my panelists to come on the stage, please. May I first request former Advocate General of Maharashtra, Mr. Senior Counsel, Mr. Ashutosh Kumbhakone, to be on the stage, please. May I now request Mr. Aditya Thakkar, Counsel Bombay High Court, Mr. Naresh Thakkar, Counsel Bombay High Court, and Mr. Aditya, Mr. Karthike, also partner Fox Mandal, to be on the stage. Thank you. We're going to start the session now, so may I request everyone to take their seats, please. We know that we're standing between you and the lunch. We will try to make it as quick as possible and as brief as possible. We apologize for the delay in the entire sessions, but we will try and keep to our time. Thank you. The overreaching theme of maybe also request everyone to wear their headphones, please.
Requesting everybody to please settle down so that we can begin with the next session. We are already a little delayed. And please wear your earphones so that you all can hear the conversation clearly. Thank you.
So our panel discussion is going to be on ease of doing business, dispute resolution mechanism, and the symbiotic nexus in modern India. For me, ease of doing business is the promise. Dispute resolution is a proof of delivery. So unless we prove that we are able to effectively resolve disputes, we will keep looking at the disputes. The World Justice Project Rule of Law Index 2025 has put India at 86 out of 143 in resolving disputes, which is better than what we were in the past. We are growing, we are making steps, we are coming up in that index. I think underlying theme of this is that we need speed, predictability in the justice delivery system, and the economic reforms, which the government is very keen on having, to have a progressive reform, progressive laws, which will help bring the ease of doing business into India. Today we are looking at India 2047 Viksit Bharat. For that, my first question is going to be Mr. Kumbhakone, former Advocate General of Maharashtra. For Viksit Bharat 2047, if India were to be known globally for one signature strength in dispute resolution, what should it be?
Firstly, thank you very much for making me part of this conclave. I thank Mr. Kunal and my junior Gaurav Sharma for giving me valuable inputs and inviting me here. If the organizers are really serious about the topic for this session, I think it has a potential of about a day's conference, full day conference. I don't think 1 hour is enough even to make in today's terms bullet points. That won't be enough, but still we'll try to do it. The most important part which my fellow panelists must note is that the board says that our session is up to 1:30 p.m. correct? Now we have already crossed that, meaning thereby we can speak without any limit. Otherwise we would be required to close by 1:30, so that's already over before we started. So we can go on and on, that's not an issue. This was in a lighter vein. Now coming back to the question, what do we look forward as Viksit Bharat? I want to quote here an incident which occurred in my life. That it was a period during 2005 and 8 when, no, not 1995 and 1998. During that period, I was working as the first Associate Advocate General for the state. The then Finance Minister wanted to suddenly meet me early in the morning, when my rule was I would never entertain anybody in the morning because I had to attend to the court, and all the meetings and conferences would be in the evening. But my secretary told me that he is visibly very upset, and it's better I talk to him at least for few minutes in the morning only. So I allowed him to enter my chamber, and he had just written the earlier night from a trip abroad, which was similar to the one which was undertaken by our present Honorable Chief Minister to Davos to attract international investment. He told me that he had arranged a small group of serious investors who wanted to invest in our state, maybe around 30 of them. And after his initial speech, that time PowerPoint presentation was not there, so he had addressed them orally. Question answer session began. The very first question asked in that small gathering by a serious investor was, "Sir, suppose I end up in a litigation. How much time will it take for the first round to get over? I want to know the result of the litigation. In the first round, how much time will it take?" The Honorable Minister said, "I remembered you as the Associate Advocate General consulting the government, efficiently handling the litigation, and I ventured to say 3 years. The investor got very upset. He said, "Mr. Minister, what makes you believe that we attend such conferences and meetings without homework? We are aware that it takes at least 10 years for a suit to get first round decided." The other investor explained to him, and that's the today's topic, the nexus between ease of doing business and dispute resolution mechanism. So what's the nexus? The other investor explained to him, "Sir, please appreciate, as investors, it is not that every investment we make proves right. Many a times time proves our decision wrong. But in the business interest, we must know the decision as quickly as possible, that we have made a wrong investment or we have made a wrong choice. Suppose that I decide to invest in your state and in partnership with somebody who is a crook. I don't know it initially. The time proves that he is a crook. So I must get out of that partnership as quickly as possible." Therefore, he said that we wanted to know how much time it takes for the first round of litigation to get over. And he told the minister that, "Look, I am not talking about the predictability, accuracy, and the justifiability of the outcome. I am talking only about the period it will take, so that if I can come quickly to a conclusion that my partner is a crook and I must walk out of it, I go to another venture, invest something." So he said that, "Minister, therefore you are here not to be fair and truthful, first. Secondly, you don't have any scheme for us for expeditious disposal of our matters, legal issues. So it appears that you are not very serious." And he told me that, believe me, 75% of those who were sitting in that small group simply walked away. Only on the first question, how much time it takes for the first round of litigation to get over. Therefore, these two aspects, which for a normal person may appear to be unrelated, namely ease of doing business and dispute resolution mechanism. For a normal person, it may seem that they are unconnected with each other, they don't have nexus with each other, but they do have a nexus. And this example, a concrete example, which has happened around 1995 and 1998, that I am telling you. Thereafter, of course, we have made lot of progress. There is an arbitration act. There are there are small scale industries mechanism where there is an institutional arbitration provided, there is mediation, and we are conscious and we are getting over that aspect. But they have a very both the topics though appear to be without nexus, they have a nexus, and of course what kind of nexus, that we the panelists will thereafter explain.
Sure. So staying with you, just wanted to ask you one more important question is that uh, we've seen the introduction of the Commercial Courts Act. We've seen specialized benches coming into play. They've of course played some positive part in resolving disputes. Things have moved a little quicker. What are the other reforms according to you, having been the former Advocate General of Maharashtra, you think are necessary for the state or the center to take on resolving disputes quickly?
See, I must tell you frankly that though I have been Advocate General for the three different colored governments who are at loggerheads with each other, almost rivals, I have represented all three of them and in continuous succession. A very difficult task that explains you why I have more grey hairs than anybody else here, and whatever are left are on their way to go. That's the reason. See, the approach of the government and semi-government agencies, the stumbling block has been that there is nobody who can say, get up and say, the buck stops at me. Again, I will quote a live example which has happened. One day, a secretary entered my chamber when I was working as Advocate General, telling me that there is a dispute of a contractor with the state where he is claiming 600 crore. And the contractor is on the verge of, his business is on the verge of collapse. He is almost bankrupt and he is ready to take whatever the government offers him. He is even ready to settle the dispute at 250 crore. His claim is 600. He is ready to settle at 250 crore. And the secretary was of the view that really he is entitled to more than 400 crores. But he is ready to take 250, forget about interest, compensation, everything, and have a what we call it as golden check hand. The secretary said, the file is ready, the note is ready, but I am not ready to sign. He wanted me to sign the file first, and then he said he will agree with my view. The reason, I asked him the reason. He said that I want to retire peacefully. After 5 years, the government will change, the minister will change, my successor will change, and then there will start an inquiry. In the recent elections, you must have heard various speeches by various ministers on various topics. The earlier government takes a decision to build a bridge. The subsequent government says there is corruption. They should have got an underground tunnel instead of a bridge. There is a corruption. So hold an inquiry, appoint a committee, and then it should result into an anti-corruption bureau complaint filed and get that man arrested who took a decision to build a bridge instead of having an underground tunnel. Therefore, in the government, the stumbling block is there is no immunity to the person who takes a decision to settle a dispute, and therefore, in government matters, I have found that mediation has always failed, and I don't think in future also it has any chance of succeeding. No compromises take place, and whatever happens, the first note written by the officer is, please file an appeal. Nobody is ready to accept the decision. That's the stumbling block.
So you bring in a very interesting point, and that's been part of debate in the recent times in almost all conferences. Whether mediation is effective in government contracts, and whether the government officers are going to accept mediation. That's been a big discussion. I'm going to straight away first invite Naresh to give his comment on a point which I know that he's been very clear about, he's been writing about it, he's spoken about it a lot. So Naresh is a counsel in the Bombay High Court, and he has a very strong view on this, and I'm going to ask him to give us his view. In the recent time, as you know, government has come out with a notification. Ministry of Finance has come out with a notification that any dispute above 10 crores should be referred to mediation or referred to court litigation, and removed arbitration from all infrastructure disputes. Now that's been followed now by PWD circulars from Delhi, and a lot of oil companies have also followed the same circular. Having seen this, and what sir just mentioned, that government officers are always going to be very skeptical about saying let's go for mediation, let's settle it, because at the end of the day their neck is on fire. So how do you reconcile the two, and what is your view on the whole circular and the way forward?
One more thing, I don't know whether you are aware or not, but what I have been told is that Karnataka State Assembly has decided to exclude an arbitration clause from all government contracts.
Yes.
They have decided not to have an arbitration clause. And the reason given is this. To a certain extent they may be right. The reason is this. As an AG, I have seen n number of arbitration awards in government. Believe me, I have always been an appellant in 34 application, and I have never seen any arbitration award which results into complete dismissal of a claim made before arbitrator. And loosely it is always said that the contractors earn real earning of the contractor is not by performing the contract but by executing an arbitration award.
So rightly said, sir.
Yes.
Naresh.
So, first of all, thank you to the organizers for having me over. And Raj, thank you for this question. I think, let me put it, let me just say this in this sense, that first things first, let's agree. And, this is something which has been said by speakers before me, and I don't need to therefore repeat it, but just at the cost of this repetition, just to put it this way, that litigation is not the way forward. Certainly not the way forward. And when I say litigation, we all understand it as court-based litigation. We all understand that speed is not the hallmark of any court in our country. And I'm not going to, go down the path of blaming anyone, because it is just a systemic fault. So while our judges unfortunately take a lot of the blame, I also firmly believe that blame ought not to lie with the judges. It is a systemic fault, and you can't fault the judges for trying to do what they are today trying to do. In fact, if you were to look at the statistics, one of the questions which was put forth in 2025 in the parliament was that to the law minister was that how many judges per million do we have in the country? And it is at an abysmal low of 21 judges per million. I mean, can you imagine, with a country of our size, to have only those number of judges, and then to expect the judges to do the job that they are doing? And to my mind, it's a tremendously onerous job that they have taken up, and they are trying to do the best. So I don't think that's the way to go. Now, if litigation is not the way forward, then you ask yourself, what is the other thing that you can truly look for? There has to be a credible alternative. You cannot just talk about an alternative and say, fine, I have an alternative, and therefore, that alternative should work. It has to be a credible alternative. Having said that, now look at the guidelines which has been issued by the Ministry of Finance, which is what you are talking about, followed by everyone. And I think I don't even need to venture out any further. I think Mr. Kumbhakoni has answered that, already, that the reason provided by the guidelines for coming out with whatever they are saying, which is that do not arbitrate, we will mediate. I mean, I am surprised that the government is talking about mediation, and why do you not want to arbitrate? if you go through the text, and I think what stands out why the government does not want to arbitrate is because according to the government, there is corruption in arbitration. That's the bottom line. That's the, look at the entire text, you don't need to read any further. It is serial number 5, Roman 2, that explains why the government does not want to arbitrate. Long and short, it is because of corruption in arbitration. Now, whether there is truly corruption in arbitration or it is just a matter of perception, in either circumstances, to my mind, you are throwing away the baby with the bathwater, as is popularly understood in the English language. World over, it is a form of dispute resolution which has worked wonderfully. Why should it not work in India? I mean, I can't understand it absolutely. And at the same time, while you have the finance ministry come out with this guideline, at the same time, India wants to become, and this government wants India to become a arbitral hub. How can you become an arbitration hub when the government, does not trust the very system that you want to perpetuate around the country, and for the world to know that you are a great so-called seat for arbitration? If you don't trust that very system, if you don't want your companies, and we understand that in India, and largely so in India, that government just does not do the statutory work, the legislative work. It also has a business arm, and the business arm does the most. The capital investment comes out of the business arm of the government. And if that arm of the government refuses to arbitrate, what is the other alternative? They are tom-tomming the other alternative has to be mediation. And I think, sir, you rightly said it. There is not one person in the ministry, and rightly so. Why will any Babu, for that matter, want to sign off on a file today, and 10 years down the line, after he is peacefully retired, have a finger pointing, not just a finger pointing at him, he will be taken down in a manner that, one would, privately nobody would expect and nobody would want to. So why are you expecting mediation to suddenly become the norm and suddenly to become the panacea that you otherwise is not going to work? And yes, and I can tell you this because the Advocate General, the Attorney General and I are in a matter against each other, and he and I just spoke very briefly, and he said that, Naresh, I'm trying to ensure that I'm trying to send out a note to the government to say that we must settle this dispute. I said, thank you so much, sir. Please do it, because the client wants to bring in further investment, but because of this, we are stuck. And we've been trying, believe me, both the Attorney General and I are trying to ensure that we can settle this dispute, but it's not happening. For reasons we all understand, it's not happening. So we continue to be in courts, we continue to be in litigation, we continue to be in arbitration. So I don't think the answer truly lies either in saying that I will not arbitrate, or to say that I will only mediate, because all of us understand that the moment you say that I will not arbitrate, the only way forward is to litigate. And the moment you go into litigation, we all understand this is a commercial dispute, it will go into a suit. It is, if at that point in time we were talking about 10 years, today we are talking of at least 20 years before a matter will get resolved. We spoke about, I don't think today the pendency is 5 crores. It is touching 6 crores. And if you were to look at the statistics, someone should tell us the statistics about pre-COVID and post-COVID. Post-COVID, to my mind, it is humongously gone up. I mean, the filing, if you were to look at the proportionate filing, post-COVID, it has gone up tremendously, which truly means that if we want to move ahead as a business community, and again, because we must understand that there is a social side to life and then there is an economic side to life. We are not able to address even the social side of life. I mean, the criminal justice system is failing. There are under trials who are languishing in courts. Do you truly expect the judges to look at the economic side of stuff and to ignore the social side of life? I don't think, that is ever going to happen. So to my mind, for the business community, the way forward is the alternative. And arbitration is a very credible alternative. Raj, you and I have both been a part of this community for a very long time, and we understand how things work. today the Arbitration Act, to my mind, gives, with the way the arbitrations are concluding, it takes 18 months to 24 months. Yes, there will always be bad apples, but largely between 18 to 24 months, you have your arbitration that gets over. Compare that to the first round, as what you are talking about, compared to the first round of 20 years. If you have in 2 years an arbitration concluding, even if there is a challenge, which you must expect in India, that everything goes into a challenge, even if it goes into a challenge, it being a money decree, equal to a money decree, the courts are very, very reluctant to grant you an absolute stay. The first thing that the court will tell you is deposit. And you deposit, the other side gets an opportunity to withdraw the money, obviously on a security to be given. So to my mind, it's an absolute no-brainer that you should arbitrate rather than going into either litigation. Mediation, yes, it's a great tool. It's a great tool if it is effectively put in practice. In India, largely, parties don't want to mediate. Mediation is taken as a tool to do what is understood in common parlance as, time pass. You are just the respondent is only trying to draw out more time insofar as the mediation is concerned. Wrong use of mediation, absolutely wrong use of mediation. And if, as I said, if put in the right perspective, if taken in the right perspective, mediation is a great tool. But if not mediation, then arbitration is the only way going forward. I don't think litigation is what we should resort to.
No, I completely agree with what you are saying, narration. I think that's the general consensus here. And if at all the government wants to be serious about mediation, then they need to empower the officers and ensure that they are not going to be questioned if a decision is taken. Their pensions, their salaries, there's no inquiry. And they need to be protected and ring-fenced so that they are then encouraged to do it. Otherwise, you create an ombudsman, get an ombudsman to decide and recommend a mediation, and then the officer will implement the mediation.
But that,
otherwise, this mediation is not going to help in government contracts.
Yeah, but that, to try to ring-fence any authority is not possible. With every change in government, I think Sir mentioned it, rightly so, that with every change in the government, you will have a new thought. And every government will want to change something of that kind, And frankly, if you look at our statutory mechanisms, you take income tax, you take, GST, erstwhile service tax, customs, whatever. Every law has a protection for an officer who's investigating a case, and yet, you can go after the officer concerned. So I don't think trying to ring fence is an answer, because you will not be able to try as much. You won't be able to ring fence an officer in all earnest that you would want to.
No, I quite see your point, and I'm the only suggesting a way out. If at all government wants to be serious and to protect, then they need to ensure to do something to protect the officers, because otherwise it's like throwing the baby out of the bathwater. You don't do arbitration, go to mediation, which is not going to be effective, or go land up in court, which will take 20 years to finish. So that I think will be a bit of a challenge to everybody. Aditya, I just wanted to come to you before I go to Karthikeya, and from your experience in commercial disputes, what are the most significant procedural bottlenecks in the Indian courts that undermine the predictability business look for, and how can commercial courts be retooled to address them?
Good afternoon. My sincere gratitude to the organizers, Mr. Vithalani, Mr. Ghelani, Mr. Vajani and Mr. Gadia, and all the organizers here for inviting me today. With respect to the query, let me put it this way. For the people here from the business community, every proceeding in court, in a sense, a suit, has multiple stages. You have the interim stage, you have the final hearing stage, you can have the execution stage, and you'll have the appellate stage. Each stage has its own myriad problems. Not in a position to address each one of them. But take, for example, one of the most common problems that we've had, and we are in fact working on, is the witness part of it, the witness trial, where evidence used to take a lot longer earlier. Now we've introduced amendments whereby you can do it on affidavit, There is video conferencing to take evidence. There are new guidelines which have come in recently. So keeping this in mind, the one sort of suggestion I would have for this area is, in arbitrations, we follow this practice where in the first meeting, you sort of lay down a schedule for the entire reference. There are several arbitrators who in fact lay down a timeline for the entire reference, including final hearing. I'm not going to venture that far, but when like the Commercial Courts Act sets out timelines for your pleadings, maybe we could consider a situation that after the pleadings also you have statutory timelines which deal with your discovery, inspection. Yes, you may not be, if you don't go to court for framing issues at that stage, considering parties know what documents are there, what is admitted, and you tell them even to file their evidence before the issues. I know I'm saying something which is very contrary to our regular jurisprudence, but then you have the hearing, in which case you can do case management, issues, marking, and the evidence is already in place, so you send it directly to the commissioner. You may actually hasten up a process, and there is some predictability because the timelines are in the statute. So according to me, that could be some way of looking at things to bring in predictability.
Thank you. Karthikeya, coming to you. In practical terms, how effective have commercial courts been in Tier 1 versus the Tier 2 cities? And what disparities do you see that might impact the overall ease of doing business narrative if not rectified in Tier 2 cities?
So as far as the Tier 1 cities are concerned, you'll see a stark difference when it comes to how the proceedings are being conducted as far as commercial matters are concerned. The legislative work was done when Commercial Courts Act was introduced, but how it has been implemented is the difference between the Tier 1, Tier 2 cities. Tier 1, you will find judges being strict on timelines, strict on the case management hearings, and then to get the disposal done as soon as possible. In Delhi, at least, what I've seen is that adjournments cannot be given for asking, and as far as commercial matters are concerned, and then there are costs imposed on every adjournment, and then every adjournment is noted there in the order sheet as well, that you had in the past taken so many adjournments and all. When it comes to Tier 2 cities, you will find it missing all these aspects for maybe for two reasons primarily. One being that there are no specialized commercial courts as such. Like if you, let's see Jaipur, I belong from Jaipur, so I have seen that in commercial courts the charge is given to a person who also handles civil matters. So while dealing with those commercial matters, he impose or bring into principles which are applicable to CPC and which affects and delays the entire process. So yeah, there is a stark difference, and that needs to be reconciled, and one of the way to reconcile would be to have specialized courts, and then to implement the Commercial Courts Act and the timelines given there in true spirit. And
Thank you. Amber, coming to you. So Amber is the head of legal at National Stock Exchange, one of the leading stock exchanges in India. For global investors looking at Indian capital markets, what are the top two, three disputes related concerns they raise, and how close is India to meeting global best practices on those parameters?
Thank you, Raj. Thank you, everyone. Thank you, the organizers, for having me here. It's wonderful listening to so many experts in legal field, and feeling quite honored to be part of this wonderful panel. All the dispute that all starts with the contract drafting and the dispute resolution clause. So I can share some of my experience because I think I'm the only in-house amongst all. So when in my own experience of last 25 years, when we have been interacting with international parties, foreign parties, dispute resolution clause always becomes a major issue in agreeing for governing law is India, or the seat of arbitration in case we are negotiating is India. Because the perception is always are the same which have been spoken about the other panelists so far in terms of delay in completion of the disputes, uncertainty in the manner in how the dispute will resolve, even in the arbitration also, because of the allegations of not having fully partial, or having corruption allegations and all those things. So the kind of overall image which is coming is not very positive, and that therefore impacts a lot in terms of putting India as one of the preferred nations for a dispute resolution. Of course, there are regulatory issues which also creates a lot of problems, and especially on the tax part. So in so many negotiations that I have been part of it, the time we spend in negotiating indemnities only from the tax part and manner in which will be invoked, that takes a lot of time, because there's a lack of uncertainty in the manner in which they involve. And the latest Supreme Court judgment in Tiger Global has also created a lot of concerns in the manner in which the tax residency will work. And while I'm not getting into the facts and the matter in the whether the judgment is right or not, and whether substance should prevail over the tax residency example, but the uncertainty which it brings in the overall manner in which the entire tax treatment happens actually creates a lot of issues and lack of confidence and trust in attracting those foreign investors. Number one. We already have a lot of learnings from the Vodafone case which has happened. So the second terms, of course, comes on the bilateral investment treaties. Whenever a foreign investors are looking for investment in India, or India is asking foreign investment they are attracting, bilateral investment treaties does provide a lot of comfort to them. So that something goes wrong, they can always invoke and seek remedies under that. But we have also seen a lot of go and back, to and fro in the bilateral investment treaties. Recently also, India has also terminated many of the BITs. So that is also creating some kind of confusions in the minds of the investors, especially whether sunset clauses will apply or not apply. So those things are also kind of impacts the overall what you can say the sentiments of the markets and the foreign investors when they are looking for a capital investments. Having said that, there are some lot of positives also which is happening, especially which you would also seeing very closely, which we are also seeing very closely about a lot of positivity in the enforcement of the foreign awards which are coming. And there has been a recent change compared to earlier, where even for foreign awards now courts are not doing that much judicial intervention that earlier it used to have earlier. I think the recent one on the Amazon case, where they have given enforceability of the emergency award passed by the appointment of the emergency arbitrator passed by the SEAC, they have given a very positive ruling on that. That created a lot of confidence in the matter. Similarly, there was another judgment in Evertel where a challenge was raised on the the partiality of the arbitrator, on the biasness of the arbitrator. But the Supreme Court did not entertain that, and they said that the IBA guidelines which was followed at the time of conflict of interest was right, and no bias was questioned during the arbitral tribunal. So these are some of the positive things which are now leading also in foreign investment. And one very important which has come very recently on the Securities Market Code. You may recall that earlier there were SEBI circulars which required prior approval of SEBI for putting any kind of options clauses in the agreements. Basically, buying or selling of a security by way of options typically is not permitted, because there are certain provisions under the SCRA Act. And SEBI has issued circulars, and then there was a Bombay High Court judgment in 2013 based on SEBI circular 2013, which said there is no such violation. So now in the Securities Market Code, the government has proposed that any such clauses which requires a buyer or seller to pay an options contract, but at a price which is predetermined and it will be arrived at under applicable law, which is FEMA, that does not require any prior approval. So that is a very positive side. And a lot of foreign investors, especially private equity funds, when they are making investment in India and who have these kinds of clauses because they want to protect their investment, and if the plan is not going back, they would like to sell off their shares and take the money back. So some of these developments which are happening, they are very positive, and from regulatory structure, that gives a very positive signal to the markets and the foreign investors who may like to bring back money in India.
So Amba, just staying with you, because you are very so closely working with NSC, and you must be seeing a lot of issues related to cybersecurity frauds and things like that. Now, so staying with that, how can dispute resolution keep pace with the modern market realities such as cybersecurity incidents, data issues, without becoming outdated the moment it starts?
Yeah, very, very important question and very relevant question. And it's not specific to exchange as such, but I think the way the entire cybersecurity framework is evolving, issues, contractual issues, and disputes to these are also evolving a lot. On the regulatory front, I'll just touch on the regulatory front. Most of the regulators like SEBI, RBI, IADA, they have prescribed a proper cybersecurity framework which all the vendors and contractors have to follow. But there are possibility that disputes could happen. So, for example, the latest DPDP Act, they have provided a provision that any disputes, any actions that is related for the violations of the DPDP Act, that will remain in the exclusive jurisdiction of the DPDP board. So, civil courts will not have. Now, but this is related to more on penalties. But if there are any contractual disputes, then there is no bar, where the alternative remedies like arbitration, etc., can be explored. So that has to be seen how it will happen. But these clauses were also there. For example, under the Consumer Protection Act and the rules, there is always a clause. The law permits that if there is a breach of the confidentiality or a breach of any such kind of issue which has happened, that will be considered as an unfair trade practice. And recently, one of the state commission in Punjab, they have also awarded, a judgment against a restaurant which were collecting certain data without the consent, and also awarded some penalty and fines also. So these are evolving, and there is always a methodology and look at it, but these can become very sophisticated kind of disputes at times to prove damages. So far, any contractual damages which has to be claimed in personam, I think courts and judicial remedies will prevail. But if it is in rem, then special courts like SAT in case of SEBI, in case of DPDP, it will be TSAT as proposed in the DPDP Act. Those will, I think, will take precedence, and they should look at given the nature of these contracts.
Thank you, Amba. That was very helpful. Coming to Naresh and Karthik, to both of you, I have a same question and want to pick your brains for both of you on the same issue. Looking at India's aspiration to become a global manufacturing and service hub, what reforms in contract enforcement and dispute resolutions are most urgent to signal to the global investors that India means business? Karthik?
So one of the factors I think which requires a lot of consideration right now is the enforceability of an award. The enforcement, if you see the timelines, the enforcement is taking more than the passing of an award. So in such situation, the investor credibility and the assurances which the investor needs from the system is lost. And therefore, we require that there should be a time mandated enforcement proceedings, and you need to segregate enforcement from the 34 proceedings. What these days is regularly happening is that a same judge is hearing both 34 and an enforcement case, and which is completely resulting into an automatic stay, because unless your 34 proceeds, the judge would not want to proceed with the enforcement. So you need a special commercial benches to hear enforcement cases. There has to be timelines fixed to enforce the awards.
Naresh, your thoughts?
So I couldn't agree more. I think that's something that I would absolutely agree with. The other thing that I think is speed and predictability. And when I say predictability, I'm talking of the consistency with which you have decisions of the court. And that is a huge problem insofar as we are concerned. Because if even in the Supreme Court, and I will cite just, two decisions which have come in a span of 1 month. And this has happened very recently in December 2025. In November 2025, you had a decision from the Supreme Court which said, so what if there is alternate remedy? If a matter deserves to be heard, the 226 court, which is the jurisdiction of the extraordinary jurisdiction of the High Court must exercise that. And lo and behold, within a month you have another decision from the Supreme Court exactly contrary. Now, this is just one of the many decisions which have come from the highest court in the country that are, opposite to each other and therefore lacks consistency. In such a situation, forget the fact that the lawyer is confused, what to do and what not to do. Imagine the investor who's coming in, who's looking at your quotes and who then, thinks to himself, well, if, what happened to Tiger Global happens to me. How, despite the fact that Vodafone said what it said, are the courts going to read differently, read it down, read me out of a treaty claim, etc.? Yes, we all understand bad facts will make bad law. But once you have the law in place, largely, law does not change. It's the interpretation of the law as we understand is what matters. You interpret the law in a given fact situation, come up with a decision, and then, in another given set of facts, you turn the law on its head. That is something that, investors do not want. They want consistency. They want, therefore, predictability, right or wrong. Like, it was said that what you want as an investor is that you want to know that whether you should come in with a safeguard or you don't come in with a safeguard. As an investor, you priced it into your deal. We must, as litigators who go on to sit on the bench, we must understand what a corporate guy understands very well. And unfortunately, as a litigator, we don't understand. Every business prices its issues in the deal itself. So don't be under the impression as a litigator. And as a counsel, I keep on telling myself this every single day, that don't tell yourself that, you are someone who's born very differently from everyone else out there in the market. What you don't know is what the corporate guy knows, and the industry knows very well that, everything is priced into the deal. You are only a medium to try and get that out of the court, whatever best that, you can get out of the court. So, to my mind, adding to what, Karthike mentioned, speed and predictability are going to be the key going forward if we have to, take India anywhere close to the vision of Viksit Bharat by 2047.
Just permit me to add
Yes, sir.
two things to the same thing. One, it is well said that real trouble of a litigant starts after obtaining the decree. So till he obtains a decree or a judgment in his favor, he is just hoping for it. Once he has a decree, the real trouble starts, namely executing it. Therefore, all of us, we have always been talking, and we have seen so many speakers and intellectuals discussing as to how to speed up a litigation, which that discussion ends with how to get a decision as quickly as possible. Rarely we find people talking about how to quickly implement that decision, right or wrong, whatever it is. So we must concentrate henceforth, in my opinion, on the executability of a decree rather than speeding up of getting that decree. Both should be equally concentrated. Secondly, there is one more point you made. Predictability, correct. There is no doubt that the law should not be stagnant, it should be dynamic, no doubt about it. Interpretation of law also has to be dynamic, it should stay in tune with what is happening around it. But that doesn't mean that a view taken today is set up tomorrow. I am just sharing one trade secret with you, if you can use that term. Whenever a draft comes to me, many a times, the draftsman, the juniors like Mr. Gaurav, they quote a judgment. They refer to the judgment and refer to the quotation. I always make it a point to remove it while settling a draft, because I don't know by the time I settle the draft, that quotation is over, the judgment is overruled. I always say that never quote any judgment in any pleading. please make it a point, whosoever is hearing me carefully, never quote a judgment, never say that in such and such case, the such and such court has held as under, and then the quotation. And then that time when you are drafting it, yes, it is supporting you. But you don't know, but by the time you file it, it is getting overruled. So you fall flat on your face when the matter is being heard. Don't ever do it.
And that's so true, sir. When I joined the profession, the first thing that I was told was exactly what you are saying. And we've forgotten the times in the past when suits were being drafted, framed, the 226 writs were being framed. They were hardly 5 pages, 6 pages, not containing, quotations from judgments or even the citations per se. There was always I was told that when you are drafting, you're not drafting to please your client, because if you draft 50 pages, your client will be very happy to when he sees a draft which is 50 pages, suddenly he has confidence. But that's not what you're doing it for. You're doing it for the judges, so that the judge will read and come. If you have a 50-page draft, the judge is never going to read. But if you have a 5-page draft, the judge might just read and come to the court.
And always plead facts, not law. Basic.
Yes. Aditya, I'll come to you. You've heard everybody about enforcement is where the confidence is won or lost. What suggestions, what ideas, what thoughts to open up the bottlenecks that are there in India today for enforcement of either decrees or awards? What are your thoughts? How can the commercial courts, or do we need a special code for enforcement for arbitral awards only? For international awards, for domestic awards, create a special court and not get stuck into the rigors of CPC, where we at the end come back and say that we go back to court, go to CPC for enforcement. Can we avoid that? Can we have a special legislation only for enforcement of awards? What's your thoughts?
So on enforcement, one more problem that I have seen recently which has come to light is, for example, in the Tata Docomo case in Delhi, apart from the parties fighting for enforcement, RBI also intervened and sought to challenge the award. So now if you're going to have a third scenario where the regulatory bodies or the government is going to challenge private awards, you have a third player for which there is no predictability today. So that is one more factor which we will need to get clarity on going ahead. In terms of speedy disposal, the concept of an tribunal for arbitrations or an arbitration tribunal has been spoken about quite a bit recently, saying that it will be a specialized body only to deal with, say, on 9, 34, 37, 48, 49. But whilst I'm not against tribunalization, I do believe tribunalization also creates a particular problem in some areas. Like sometimes you have an overlap of subjects. One tribunal can't deal with the entirety. So then the same matter gets split between 3 or 4 tribunals. Like for example, the issues right now about the telecom sector, where a lot of these companies are in NCLT, they're also before TDSAT, they're also before the High Court, all arising from the same set of facts. But if you had one forum, that is going back to Naresh's point, that we have such few judges, if you had more judges in the High Court itself, then it would be one forum which could hear everything. Like he said, we have 21 judges per million, or at the moment I believe around 1100 judges, High Court judges. So you do need more judges. I think it's one thing which is like, you don't even need to say it because of the amount of work people are doing. Within the confines of the system, I'm really not very sure how many effective solutions there are going to be unless we start thinking a little more out of the box.
Yeah, so I think my thoughts or my concerns on tribunalization is that today 80% of the disputes are government on one side. And if you have a tribunal in place, are we making it pro-government in that sense? And therefore, independence, impartiality, party autonomy all out of the window. So are we actually disturbing the bedrock of arbitration and enforcement as a process, where we bring in another tribunal in place where you have government, 80% of the disputes are government?
Absolutely.
So do we need that at all? And I'm a little skeptical about it, honestly, about how it will work. We've seen with what's happening with NCLTs. We've seen with other tribunals. Do we want another problem at our hand? Is something that we have to be very careful with. But sir, you've been seeing it up close and personal. What, according to you, could be the good solution to clear up the bottlenecks on enforcement? Be it awards, be it judgments, what would your views be?
See, first thing first, I think that as we have in the High Court presently a separate court for arbitration, we could have a separate judge assigned with only execution. And if that's not possible, a sitting judge can assign out of 5 working days, few days, at least 1 or 2 days marked only for execution. And if that is also not possible, in a day, at least a half day, I will take nothing else but only execution. So there has to be a block, so to say, before a judge where he will take nothing else but execution. Presently what is happening is the execution matters are getting intermixed with regular matters, and therefore, as I said, the real trouble of the litigant starts after obtaining the decree. So some are fighting to get a decree, and those who have got a decree are in a worse position. That just like all of us, lunch is ready, but we are not able to go there.
So I'll have a couple of last concluding thoughts from all of you. One myth about the arbitration you'd like to bust, Amber.
That there is issues of impartiality and corruption.
That it is cost effective.
Well, I'm going to here disagree with my learned friend, and I'm going to say that it is cost effective, but if you run it correct. And I think the biggest problem that and a lot of Amber knows it well enough that a lot of GCs when I speak with, and I am a part of a GC community where people talk about how expensive arbitration is and why we should not go and arbitrate. I actually tell them the other way around. If anyone wants to talk to me in private, never express views in public. But I always tell them that, it depends on your arbitrator. It starts with your choice of arbitrator. If you've not chosen right, then you sow, you reap what you sow. So if your starting point is wrong as a GC, then you're thinking incorrectly. So I don't think arbitration is expensive, because ask any businessman the time value of money and they'll tell you that what they spend in arbitration today to get the reward, they would rather do it rather than spending 20 years or 2 decades fighting a litigation.
True. Aditya?
Let's say this. With cooperation, it can be time effective.
Sir?
I'm very eagerly awaiting to see an arbitral award against in respect of a contractor suing a government where his claim is completely dismissed.
Sir, I'll send you one.
I'll also send you one.
I'll send you one, sir.
Please, I'm eagerly awaiting. I want to see it.
Yes. If you were to suggest one reforms to improve India's ranking in ease of doing business, what one legal reform that you would want to consider?
One is that, as I have been saying just now, please expedite the execution part of the award rather than the delivery part of the award. Execution part, please expedite. It should be at least 1/4 of the time that the award has taken for delivery. In 1/4 of the time, the award must be executed.
Aditya?
To support this, like I said, more judges, more courts.
I think I would think on the IBC side we need to change our mindset. It's from trying to liquidate. Actually, you try to resurrect a company than trying to liquidate. That mindset needs to change on the IBC side, because we have a great law in place, but it's how the law is being implemented, to my mind, is absolutely incorrect.
we need to borrow timelines. As far as arbitration is concerned, we need to borrow timelines from IBC and implement them.
I think I have two points. One, bringing harmonization in conflict of laws. That at least we see so many laws comes and they play. You have SEBI, IBC, then general corporate, this and that. So it becomes very, very complex. Harmonizations in the conflicting of laws. Second is certainly and without doubt certainty of tax treatment, because when the global investor, they look at tax is something they are really concerning. So bringing the certainty is really going to help.
Thank you. So to conclude this, I think the three things that I have kind of got from the entire discussion today, and even from our earlier panel, is predictability is productivity. If you have predictability, you will have productivity. Business confidence grows when outcome times are known. Pre-dispute discipline matters. Having right kind of clauses, as you mentioned, in your agreements is important right from the inception, rather than wait and see what's the outcome in court. So have a clear and concise clauses in your agreements to start with. And of course, enforcement completes the promise. The system's credibility is measured by the real world outcomes. And therefore, we have to all see how we can get that outcome that is desired by the business community at the end of it. Eventually, we have to have an award which is enforceable, a decree which is enforceable, and not just the paper on which it is written. So I think something we need to do, and I think we will reach there. There are a lot of ways in which this can be brought into by bringing, as Sir has rightly said, think ahead, think for the future, what can be done, how we can reduce these bottlenecks. Thank you all for your patience. Thank you for waiting even during the lunchtime, and thank you. We are very grateful to you. Thank you all. Thank you to all the panelists. Thank you.
This is not a self-invitation, but I will really appeal to the organizers that if they are really serious about it, please hold a one-day conference at least, because this topic itself has a great potential, and it will definitely help the business community, and I'm sure all of us will be invited at least as audience, if not as speaker. Thank you everybody.
Thank you everyone. I think Mr. Mahendra Ghelani is coming. He will be addressing the gathering briefly. May I request you all to please wait for 2-3 minutes. He's just on his way. I've just been told that he's coming. So request you all to please be seated. He's just on his way. Okay. In the meantime, may I request Kunal to please hand over a token of memento to all our panelists. We promised, as promised, we tried to keep it on time and within 1 hour. Thank you.